Utah versus Kouri Richins. She is accused of poisoning her husband. She is accused of attempting to poison her husband before he passed from a fentanyl overdose. The bail hearing I covered, and it was illuminating. She got into a fist fight with her sister-in-law over his estate. He, it seemed, had some reservations about where the marriage was going. She seemed to know, based on her text messages, that if they got divorced, then under the prenup, she gets a zip, and was having some financial struggles, some substantial financial struggles. And if he died while they were married, she took half of his business that he owned with a business partner. So his portion of the business, the house, everything. What she was unaware of is that he had put everything in the name of his sisters, like a trust that his sisters were in charge of. So she did not get the house, the bank account. She was trying to break into the safe when the sister-in-laws stopped her. So the victim, Eric's sisters, became the executors. There are multiple civil lawsuits going on with regard to the estate of Eric Richins. In the bond hearing, we learned about the substantial financial struggles Kouri Richins was going through, the text message back and forth to purchase the substance that ended up into her husband's Moscow Mule. We saw the walk the dog letter where she said it is a fictional story, but seems to perhaps be open to interpretation of her and her mother and brother trying to get their stories straight. We've heard a number of her jail calls. By heard, I mean we've gotten transcripts of them, not actual audio of them. We have had audio from Kouri Richins because she released a statement to the media because she wanted everyone to know how unfair it is the way she's being portrayed. And so she left like voicemails for a podcast that is connected to Dateline. She is charged with 1 count of aggravated murder for the death of her husband, Eric Richins, from March 3rd, 2022. 2 counts of possession with intent to distribute a controlled substance, mortgage fraud, 2 counts, fraudulent insurance claim, 2 counts, and 3 counts of forgery. So there is a lot that was added on later in the case. Her attorney, Skye Lazaro, left the case, and so she has new attorneys. She's pending preliminary hearing. She's been in custody almost a year now. She wasn't arrested till a little more than a year after the death of her husband. And in the intermediary, she wrote a children's book about how to deal with the grief of losing her husband. She also was, the one that was Googling things like luxury prisons for rich people and Googling how to pass a lie detector test. Can deleted text messages be recovered by police and things like that? The walk the dog letter, because it said walk the dog across the top. There's been much argument over whether this letter was attorney-client privilege communication, which if it is a manuscript, it can't be. But she argued it was attorney-client privilege. Her attorneys argued that it was part of a larger manuscript, that it was fiction. Again, if it's fiction, it's not attorney-client communications. But it seemed like setting up a story with her mom and brother. And it's like, remember. And it seemed that she was doing this on video calls with her mother and holding up the letters because jail calls are recorded. In that letter, she also tried to have her mom smuggle her Crest white strips because she wasn't really happy with how she was looking in her televised court appearances. So this is a very interesting defendant to me. And in the motions that have come out, because the defense will do something and then the prosecution's like, oh yeah, here. And the prosecution keeps adding all of the information that they can into their motions. We've learned that there were also text messages between Kouri Richins and a paramour. So we don't know much about the paramour, but we know that there is insinuation per the prosecution's motions that not only was Kouri Richins having substantial financial difficulties due to overextending herself in real estate, that she was, the prosecution alleges, forging bank statements to take out mortgages on houses to buy new houses. And while all this was going on, she is playing nice with her husband while texting about not really adoring her husband, and then also texting her paramour. The first time she attempted to poison her husband, as alleged by the prosecution, was on Valentine's Day. She made him a sandwich to take to work. It made him incredibly ill. He called friends to tell them about it. She subsequently texted and asked for stronger fentanyl, and then he was killed on March 3rd. So from February 14th to March 3rd, there's quite a lot of texting activity, a criminal mastermind. It seems Kouri Richins is not, but what it is a very interesting case. And I was blown away at the bail hearing when her sister-in-law got up and started talking about Kouri Richins, like throat punching her days after Eric Richins died over the safe with his money and weapons and things in it. So the children's book, The Luxury Prisons for Rich People, the paramour of it all, the prosecution has been spilling the tea and the defense is big mad. Here's why. Defense attorneys for Kouri Richins have argued that the entire district attorney's office needs to be removed from the case. They are trying to yeet all of them. Why? They say that the district attorney's office have invaded attorney-client privilege in a number of ways. This motion was filed the same day. Like a whole bunch of motions were filed by Skye Lazaro and her law firm before she also filed that she was removing herself from the case. I'm surprised it took so long after that walk the dog letter, but whatever. Skye, leaving the case after these motions were filed, leaves the now appointed public defenders to deal with these motions to recuse the entire DA's office. So they're alleging that the district attorney's office invaded the attorney-client relationship by accessing the rest of the walk the dog manuscript and by listening in on attorney-client phone calls. When the district attorney's office responded to that, they said, yo. So there's separate phone lines to call in. If you're an attorney, you can call in and talk to your client using a particular app and going a different way. If you just call in on the public line, you are met with, this call is being recorded. Her attorney was calling in on the public line, this call is being recorded. And when they dump all the public calls to the DA's office, they were going to the DA's office and the DA's were then like, and this marking the calls that were with her attorney once it became apparent that that attorney was the one talking to her, and then not listening to them. And the DA's office was very clear. Look, first, we're not listening to your calls. Okay. Second, if you call in on the public line when there's an attorney line for you, we think you're waiving privilege. That said, we're not pushing the issue because we're not listening to your calls. But we know everything that you're talking about with your client because she's calling everybody else and telling them what you said. So all that we know about the attorney-client communications are from your client telling her mother, her brother, and whoever else. Telling another person, telling your mom, hey, I'm talking to my lawyer. She's a dumb bitch. Yes, that's in the transcripts of the jail calls and blah, 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 blah. It absolutely voids any attorney-client communication, right? You're telling it to a third person. That's not privileged. Kouri telling her mom what her lawyer said is not privileged. Her communications with her lawyer are. So the DA's office was saying lawyer needs to call in on the app. But DA's office also said, hey, lawyer doesn't want to call in on the app because the lawyer thinks that the app is going to track their entire phone or whatever. And we know this because Kouri was telling her mom and brother about that on her other calls. So the DA's office said everything we know about what's going on the defense side is because your client's telling everybody about it, not because we're listening to your calls. The defense was not persuaded by that, but the defense also left the same day. So they're like, hey, Your Honor, the DA's office needs to be recused. Also, we're out of here. So I think it's an interesting argument that the defense attorney calling in on the public line, knowing it's a public line, knowing it's a recorded line, when there is the option to call on a non-recorded line, might be waiving privilege. Is anyone taking up that very interesting legal argument? No. Do I think someone should put that on a law school exam? Yes. I think it's a really interesting question. Does knowing the calls being recorded void attorney-client privilege? interesting, fascinating legal question. Are we here today to ponder all of this together? No, we're here to take a look at what happened in court when this motion came for hearing. The motion is to yeet the entire DA's office.
The issue before the court is defendant's motion to disqualify the prosecution. Defendant requested in order either disqualifying the Suffolk County Attorney's Office in whole or disqualifying Mr. Bloodworth as a prosecutor. The factual allegations upon which defendant's motion is based are twofold. First, that Mr. Bloodworth listened to certain attorney-client privilege communications between defendant and one of her attorneys, or prior attorneys, Mr. Ramzi Hamidi. There's no credible evidence that Mr. Bloodworth or any other agent of the state has listened to any attorney-client privilege communication between defendant and her counsel, other than a few occasions on which Mr. Bloodworth listened to the minimal amount of time necessary to identify Mr. Hamidi as a participant in the call, and after which Mr. Bloodworth promptly stopped listening and moved on. The second factual allegation upon which defendant's motion is based is an incident on March 26, 2024, during which jail staff, specifically Sergeant Thomas, would not allow defendant to pass a notebook to her counsel, prior counsel, Ms. Lazaro, until after jail staff had read each page of the notebook. And there's no credible evidence that Sergeant Thomas did or even attempted to read the substance of any page of the notebook, as opposed to merely scanning the pages for words, diagrams, or contraband that implicated a safety concern for the jail or jail staff. Based upon an independent review of the record, the court finds that neither Mr. Bloodworth nor any other agent of the Summit County Attorney's Office has intentionally or purposefully intruded upon the attorney-client relationship between defendant and her counsel. And the Summit County Attorney's Office has not directed the Summit County jail staff regarding the conditions of defendant's pretrial detention. Based on those findings, the court concludes that no per se violation of defendant's Sixth Amendment rights has occurred based on the conduct of the Summit County Attorney's Office. And based on the record before the court, disqualification of Mr. Bloodworth or any other attorney in the Summit County Attorney's Office is not necessary to maintain the fairness of these adversary proceedings. In sum, defendant's motion to disqualify is without credible basis and is denied. The court will issue written findings of fact and conclusions of law to preserve an appellate record and will issue that written ruling in the near future.
This hearing would have been a lot shorter if the DA didn't need to make a record about how pissed she was, something that was acknowledged by the judge when the judge said, "I can understand why you're pissed." But the court ruled in favor of the district attorney's office, denied the defense motion to yeet the entire DA's office and yeet Mr. Bloodworth, the DA. This case is getting ready for preliminary hearing in Utah. They say it's going to take 3 days. I don't know why, but they say it's going to take 3 days of preliminary hearing, probably to go over all the financial records. So it's going to feel like a mini trial with no jury. The rules of evidence aren't quite as finite. You can have evidence that is hearsay when offered by law enforcement and things like that at preliminary hearing. But I wonder if they're going to bring in quite a few percipient witnesses. They did that for the bail hearing, which, if you have not watched other coverage of the Kouri Richins case, there is a playlist for you. The walk the dog letter and the bail hearing will get you all caught up to speed. But if you want the tea and me reading dramatically her jail calls, that is in some of my other coverage of this case. Not a lot has happened since her attorneys left. This was the big motion that was pending before the preliminary hearing starts, and we know that it's been denied. And this will move to preliminary hearing, and then it will probably be about a year after preliminary hearing before we get to trial. Could be faster, but I wouldn't hold my breath on that. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.